If you love liberty, declare your independence by signing the Shire Society Declaration at shiresociety.com.
Party of New Hampshire, and I'm kind of pulling double duty here on this bill. I definitely oppose this. I don't think that there's a bill that you will hear that I could oppose more than this, other than possibly HB 497. What 240 would do is repeal the authorization for political parties to provide for an alternative method, aside from the statutory method, for determining the date, time, call, and purpose of their convention and for selecting delegates to their state convention. This would then require all political parties, including now the Libertarians, to elect their delegates at the state primary. This would then force the Libertarian Party to either violate state law by not electing delegates at the state primary, or violate party rules that say that you must be a member of the party in good standing, having paid dues at least 30 days before the convention in order to be a delegate to the state convention. So either we're going to have people that are delegates to our state convention that are not members of the party, or we just wind up telling people, no, you can't run for delegate at the state primary. So it would put us in a very interesting predicament, and I can almost guarantee that there would be a lawsuit, and there actually was in 1989, and the U.S. Supreme Court, in the case of the San Francisco County Democratic Central Committee et al., including the Libertarians, Supreme Court ruled, quote, a state cannot justify regulating a party's internal affairs without showing that such regulation is necessary to ensure the elections are orderly, fair, and honest. So HB 240 and HB 497 are almost certainly guaranteed to be unconstitutional if passed. So I think you should save yourself a lawsuit and IPL 240 and 497.
Thank you for your testimony on 240. Are there any questions for the speaker? I'm seeing none. Thank you for your testimony. I have also signed up to speak on 389, Mr. Perry, Darryl Perry.
Thank you. Again, for the record, Darryl Perry, CEO of Liberty Lobbyist LLC. And HB 389 actually does more than just change one line to extenuating circumstance. It makes three changes. And the first change is the reason I'm opposed to this bill. The first change is it changes any voter to any registered voter with a disability, which seems to be that someone with a disability who is not currently a registered voter would be prohibited from registering to vote on election day in accordance with state law. The other changes are the extenuating circumstance, and instead of being marked as voting in person, they would be marked as having voted absentee. I don't know what the purpose is of changing it to they voted absentee instead of in person, since they were physically at the polling location, they just weren't inside of it. But my opposition, first and foremost, is the change to any registered voter, and that's on line 2. So if the word registered were stricken, so that a voter with a disability could still register to vote on election day, I would not oppose this bill. But as it stands, it's unconstitutional.
Thank you. Questions for Mr. Perry from the committee? I've seen none. Thank you, Mr. Perry. Also signed up to speak on 497 is Mr. Perry.
Thank you. Again, for the record, Darryl Perry, CEO of Liberty Lobbyist LLC. And a lot of the points that I made regarding HB 240 apply to HB 497 as well. Plus, if adopted, this would put the Libertarian Party of New Hampshire in a very precarious situation of either violating state law by not binding our delegates, or violating national party rules by binding our delegates, which is something that is specifically prohibited by the Libertarian Party national bylaws. So if the Libertarian Party retains ballot access through 2020, we have the primary, we don't find our delegates because we actually want our delegates seated at the National Convention. Then in 2024, if we are still a party, we would be prohibited from having a presidential primary because we violated state law by not violating party rules. So I think this is, a solution looking for a bigger problem than it is. This is something that would best be handled, as Representative Porter mentioned, through amending the party bylaws to handle it that way. This does not need a statute. And again, I believe it is blatantly unconstitutional and would most likely be challenged if passed.
Thank you. Questions for Mr. Perry? Representative Harrington.
Thank you, Madam Chair. It sounds like what you're saying to this is where I'm getting a little confused. What's been added here is a penalty for violation of existing law. So what I thought I heard you say is that the Libertarian Party does not comply with existing law, but there's really no problem because without this bill, there's no penalty for violating it.
Well, the Libertarian Party, firstly, hasn't had party status. So because we've not had party status, we've not had a primary since the 1990s. But even when we did have primaries in the 1990s, Libertarian national bylaws still prohibited the binding of delegates. What this says is that the Secretary of State shall apportion delegates. It doesn't necessarily mean that they are bound per se, but what the added language would specify is that if they are not apportioned in accordance with this specific thing. So if, let's say, Larry Sharp winds up getting 20% of the vote in the New Hampshire Libertarian Party primary in 2 years, unless we have exactly 20% of our delegates that vote for him at the National Convention, then we would be in violation of this. Now, again, party rules prohibit the binding of delegates, so there could be something to where it's a coincidence that the number of people vote a certain way at the convention, but specifically binding, and again, that's just one candidate. So unless everybody had the equal number of votes in accordance with what is deemed to be the proper apportionment, then we would wind up losing the primary. But again, if we blatantly say, yes, we are binding our delegates, then the Libertarian Party National Committee would not seat any delegates from the state of New Hampshire, and then people in New Hampshire would be disenfranchised in the party vote. So you're putting, parties other than Republicans and Democrats that have bylaws that specifically prohibit binding of delegates in a precarious situation of, do we violate party rules and not have our delegates seated, or do we violate state law and lose the right to a primary?
Follow up?
Representative.
Thank you. So it sounds like what you're saying, the existing law that has the Secretary of State apportion delegates is basically meaningless and doesn't do anything because nobody has to follow it, and at least in the case of some parties, not just the Libertarian, but apparently the Democratic Party, the Secretary of State does his thing and says, here's the apportionment, and then the Democratic Party says, well, we really don't care, we like super delegates, so I take your apportionment and, file it someplace.
Right, it does seem as though there's, a statute that might not necessarily be able to be enforced because party rules do allow for alternative methods of delegates as well.
Thank you for your answer, Representative Pearson.
Thank you, Madam Chair. Seeing someone from the Secretary of State's office in the room here,
Who happens to have a pink card.
I was just going to say, would it be appropriate to bring them? I've got some questions I think we might be able to ask.
Yeah, I think so. Any other questions for Mr. Perry? I'm seeing none, thank you. Also signed up to speak on this bill is Darryl Perry.
Thank you. For the record, Darryl Perry, CEO of Liberty Lobbyist LLC, and I'm opposed to the bill. What I'm hearing from the sponsor and the other speakers is that we need to pass this bill because of electioneering. Well, let's look at the wording that's currently in statute that says that a political advocacy organization means an entity that spends $5,000 or more for communications that is functionally equivalent to express advocacy and is interpreted by a reasonable person only as advocating the election or defeat of a candidate. The proposed modification here would change this to say you put out a communication that refers to a candidate. I can think of several entities that are not political advocacy organizations that put out literature that refers to candidates. The League of Women Voters puts out a voter guide where they send candidates questionnaires and then they publish the answers. They refer to candidates by mentioning their names and providing the answers or saying they did not fill out the survey. My reading of this is if that is distributed within 60 days of the primary, they would then be a political advocacy organization and forced to file a bunch of paperwork for something that they are not intending to do. The League of Women Voters is not intending to advocate for the defeat or the election of a candidate. They are trying to educate voters about who the candidates are. This could also be construed to turn virtually every newspaper, television station, radio program, and magazine in the state that refers to candidates into political advocacy organizations if they refer to a candidate, regardless whether the communication advocates a vote for or against a candidate. So you write a newspaper article about Representative so-and-so voted this way, well, you're referring to a candidate and you're communicating something about the candidate. So I see some free speech, potential free speech violations here. There's also the American Civil Liberties Union and the Live Free or Die Alliance and several others that send out candidate questionnaires. They're not advocating for or against, but they refer to a candidate. Further, the proposal strikes the language advocating for the success or defeat of a measure. And this strikes that so that somebody could spend $89 million advocating that Constitutional Amendment Proposal 1 be passed or defeated, and they would no longer be a political advocacy organization based on the new statute here. And I don't think that is what the sponsor of the bill intended. So I definitely see some issues all around with this and would recommend that the bill be IPL. And I'll attempt to answer any questions, but based on the way some of these have been worded, I don't know if I can.
Thank you. Questions for Mr. Perry. Representative Porter.
I'll waive too.
I'm going to have you all swear it in before the session. The way this is going. That's good job, everybody. All right. Any other questions for Mr. Perry? I'm seeing none. Thank you.
We'd like to invite you to visit freekeen.com. Freekeen.com features audio, video, and blogs chronicling the transition to a voluntary society. Freekeen.com also has comments and discussion forums so you can be heard. Freekeen.com.
I should be in Keene, New Hampshire with the Free Staters.